and the dreadlocks. And they are saying this with specific reference to accused number 3. In other words, the state seeks to tell this court that in their evidence in chief, they were only concerned about the identity of the suspect who got into the house, the gun-toting suspect, by way of his clothing and the dreadlocks. But now this is a misnomer. This is not the case. Because Brigadier Kininda specifically indicated that when he made an application to the magistrate for the warrant of arrest of the accused, he specifically indicated in Exhibit 20 ZZ and this is what it says in Exhibit ZZ, that photos downloaded and taken of the accused by himself, in brackets selfies, match the description of the suspect, who had a firearm with dreadlocks, big eyes, and with a gold teeth. This is the suspect that went into the house, made a demand of a cell phone and money. He's also the same suspect that shot the deceased in the matter during the struggle with him. Now, with this information, it is therefore not accurate to say that the state only concentrated on the clothing of the suspect and the dreadlocks only, because this evidence, which was introduced by or through the affidavit of Brigadier Kininda, which was admitted on record as Exhibit ZZ, there is also specifically referred to the golden teeth, or the gold teeth that this suspect is described in the paragraph that I've already read, had. But even beyond that, when I cross-examine Brigadier Kininda, with this information that is contained in this paragraph that I've just read, I requested him to specifically refer us to Exhibit XX, to Exhibit S, where these identifying features of this in this suspect were, or in this suspects were the suspect with the dreadlocks, the big eyes, and the golden teeth. He tried the best that he can to identify the suspect with the dreadlocks. I even said to him, no, it's not in dispute that accused number 3 on the day in question, on the date of the incident, had dreadlocks. This is apparent from the selfies that he actually took himself on the day of the on the 24th, on the 26th of October 2014. But the description of the dreadlocks that is mentioned by witnesses who were in the house differ materially from that which from the dreadlocks that are visible in the selfies that he took. The big eyes, he tried to give an explanation that I still cannot even understand now. But the issue here is about the gold teeth. When Brigadier Kininda was requested by me to direct us to a photo as contained in Exhibit S, a photo that denotes that the suspect had a golden teeth, he referred to this court to photo number 15 in Exhibit S. He specifically referred to this court to number 15 and said that is accused number 3, and there's a golden teeth. And in fact, that photo number 15, I'm not an expert, but when one looks at it, is a photo that would have been taken on the 24th of November 2014. On the 23rd of November 2014. When one looks at it, to the right-hand side of the upper teeth line, I don't know what we call it now. Yes. There appears to be something that is shiny there. I will assume that's the gold, and that is exactly what Brigadier Kininda referred to when he said, yeah, no, this is accused number 3, and we can see here that on the upper, on this upper jaw, there's a golden teeth. Now one wonders whether the picture that is denoted there is one of accused, exemplifies accused number 3, or that's a picture of accused number 3. It is clear to all and sundry, and this is beyond reproach, that cannot be accused number 3. That is not accused number 3, and that will never be accused number 3. Now, the state further seeks to justify the fact that it is basically the state, and I'm killing this from the heads of argument of the state, that this information was extensively canvassed by the defense in the cross-examination of Brigadier Kininda. That is incorrect. That is incorrect. We never at any point ever suggested that accused number 3 had a golden teeth. That was not our evidence. This evidence came from the state itself. It is Brigadier Kininda who, when he made an application to the magistrate for the arrest of accused number 3, made this, indicated in his affidavit that accused number 3 had a golden teeth. And that is contained in his affidavit. Now the state seeks to justify their omission to lead to this evidence by saying that it was canvassed by the defense. As I'm saying, it was never our case. We have admitted many a time that most of the photos that are appearing on Exhibit S, indeed, some of them are selfies, some of them are photos which denote how accused number 3 looked on the 26th of October 2014. But at no point, did we ever made an assumption that accused number 3 at some stage had a golden teeth. And in fact, I remember when Brigadier Kininda was testifying, if my memory serves me well, there was an issue with regard to the doctor who took, where accused number 2 was taken for a dental investigation on whether or not he had a golden teeth. I remember the doctor came and told this court, or there was information that was placed before court here that the doctors are able to see whether or if a person had some gold dentures or something like that, or some golden teeth, irrespective of the period that they had been having that golden teeth. And I specifically remember the court saying, no, it can't be. A person who had a golden teeth in 2014, it is impossible for them to, it is impossible for doctors to come and state with certainty that after 6 or 7 years, or even 14 or 8 years, to come and say that such a person had a golden teeth. But the doctors, insofar as Ntanzi was concerned, that doctor who came here, that medical doctor, he was able to tell that Ntanzi never had a golden teeth in 2014 when his examination was done in 2020. That is one of the requests that we actually put forward, that if the state insists that accused number 3 had a golden teeth, because this is their evidence, we are going to request that accused number 3 should go through the same process as well for determination by a medical expert whether or not accused number 3 had a golden teeth at the time of the commission of this evidence. But importantly, again, my lord, is the fact that at the time of the presentation of this evidence, the state already had this information. The state alleges that they gave us this information just before the commencement of the trial, which was contained in those 700 photos. We don't dispute that. It is indeed so. But the question therefore is, and I cannot doubt that the state did a sterling job, did a proper investigation. Each and every piece of evidence that they wanted to present to the court, they went through it, analyzed it meticulously. And I'm not only speaking about a state that was seated as an individual person. I'm talking about a state that was a case that was prepared by 3 extremely experienced prosecutors, advocates, extremely competent people. I may also add that I have no doubt in my mind that the head of the department of the Director of Public Prosecutions here, Pretoria Advocate Mzinyathi, would now and then come and check whether or not the investigation or the evidence that the state was trying to gather in order to come and present here was all in place. Now, it strikes one very, very strange that at the time of the presentation of such a crucial evidence, the state would have missed these particular photos that they seek to present now. And the state specifically says, no, we're able to identify these photos at the time at which Advocate Mnisi was afforded the opportunity to go and prepare, whilst reading for those 40,000 pages, to come and assist accused number 1 in the cross-examination of Brigadier Kininda. I know, my lord, there is nothing wrong. There's nothing wrong in the state to continue to investigate the case whilst the trial is proceeding. But this is totally different because the state already had that information. If this information was material and if this information was relevant, when I say information, I'm referring to the pictures of accused number 3 that the state is seeking to introduce now as new evidence. If this was so material and so relevant, it would definitely not have skipped the state's mind. This is just a pure indication that this information is totally irrelevant, because had it been relevant, it would have been led by then. Introduction of a new evidence in the course of a trial or when the trial is proceeding has got a propensity to prejudice the case of the accused person, because accused person then has got to take some 100 steps backward to try and fathom what is it that could have been said against him, what is it that had all of a sudden prompted the state to come with this information. Could this be in line with this defense and all those factors, my lord? But the primary consideration here is that there is no valid reason why this information was not accused by the state in the examination in chief of Brigadier Kininda, based on the background that I've already sketched out. Reference might be had to all the cases that deal about the fairness of justice, what is contained in state versus Hepworth and everything. But the state needs to come up with compelling reasons, not just reasons of a cursory nature, but compelling reasons why they did not provide this, or they did not bring forth this evidence through Brigadier Kininda, when he testified in his evidence in chief, my lord. I would therefore request that in the interest of justice, that this evidence should not be admitted, my lord. Thank you.
Yes, Mr. Ramasipedi.
If it may please the court, my lord, I have overnight prepared short heads of argument in response to an application by the state to lead the following evidence in respect of Mr. Sibia, 2 additional photos, in respect of Mr. Ntanzi, 16 additional photos, and in respect of Mr. Mngube, additional 3 photos, my lord. And in our heads of argument, my lord, at introduction, we're saying that the state has made a substantive application in their quest to have Warrant Officer Ndlovu, who is responsible for the downloading and analysis of the photos that were contained in the memory card belonging to a phone that is attributed to Mr. Ntanzi, and Warrant Officer Mabasa, who dealt with the analysis and download of the photos belonging to warrant to Mr. Mngube. In respect of Mr. Sibia, we are not told who the downloader of those photographs are and the source of those photographs, my lord. And my lord, in the heads of argument of the state, at paragraph 1.4 thereof, it is stated that the state would like to re-examine Brigadier Gininda on these additional photos of accused number 2 and 3. And at paragraph 1.5 of the heads of argument, it is submitted that, and I quote, the sole purpose for such a re-examination is to put a full and fair picture before the court to enable the court to adjudicate on the issues that are in dispute, namely the identity of the perpetrators who invaded the Khumalo's home on the 26 October 2014 and killed the deceased. It is therefore submitted that the evidence is relevant. That is the heads of argument of the state, my lord. Now, our submissions in respect of, in particular, Mr. Ntanzi, is that my instructions are to object to the recalling of Warrant Officer Ndlovu and denying the state to adduce these additional photos, especially in the context for which the state seeks to introduce them, that i.e. to cross-examine, to re-examine Colonel Gininda on the description and the identification. And particularly, my lord, let me go to this. At paragraph 2.2, in fact, before 2.2, my lord, there's a passage that is very, very germane. Yes, at page 5 of the heads of argument, the state went to length to quote a passage where I had an interaction with Brigadier Gininda. And in particular, I remember vividly what the interaction was all about, my lord. I was putting to Brigadier Gininda in respect of what the witnesses in the house, some of the witnesses in the house described the second intruder. And my submission to him was that all of the witnesses in the house, when they spoke to Warrant Officer Steenkamp of the Facial Identity Kit Section, the Facial Identification Unit of the SAPS, they never described how the second suspect that entered the Khumalo household looked like. Now, if the exercise of the photos, according to the state, is to then canvass this issue, my lord, we are going to make the following submissions at paragraph 2.1 of our heads of argument to say the 16 or so photographs that the state seeks to introduce are not new evidence. These photos, at the time Warrant Officer Ndlovu testified initially in this case, we were told that download analysis were done on the SIM cards and the SD card belonging to accused or Mr. Ntanzi in respect of those devices being found in his Samsung cell phone. Now we are saying, my lord, at 2.1 that the state had ample time at the time to lead Warrant Officer Ndlovu on the totality of all the photos that were germane in their examination of Warrant Officer Ndlovu at the time, not as an afterthought. If the state, my lord, we submit, were using a stratagem that we are leading this, we are leaving this out as a strategy, not as an omission, not as an oversight, not inadvertently, then we are saying, my lord, they must lie on the bed that they made. They adopted a particular strategy. Now they come later and quote Hepworth. Hepworth does not assist the state, my lord. Hepworth says an omission by another party should not be taken advantage of by another party, my lord, in proceedings. And Hepworth also deals with the duties of the presiding officer, who we are told is not an umpire. He directs proceedings to make sure that justice is must go into investigating matter of a subordinate nature on the fringe of the case. It is important that a trial should not be unduly prolonged exposure by an over-elaborate examination of minute details which cannot materially affect the central issue. The central issue, my lord, here is identification, and identification by who? Not by Brigadier Gininda, but by the witnesses that were inside the house at the time the offense was committed. And that description and identified as given by the very same witnesses 3 days later or 2 days later on the 28th of October 2014 after the commission of the offense to a person, an expert in the SAPS who deals with identification, facial identification, being Warrant Officer Steenkamp. Now, at 2.3 that I've referred to as an anecdote, the state states, we therefore submit that there will be no prejudice to the accused persons by submitting this evidence. And it ends there. My lord, prejudice is one of the factors that the state should have gone into some length, because this matter, my lord, has dragged on. And the prejudice to the accused persons, all parties involved, the families of the deceased, need to see this case coming to an end. And recalling this witness simply to give additional photos that add no value to the issue germane to the identification of accused or Mr. Ntanzi in particular, serve no purpose, my lord, and prejudices the accused persons, all of them, the 5 gentlemen before this court, extensively, my lord. Furthermore, my lord, at paragraph 2.4 of our heads, the state sought to base their heads of argument on section 167 of the Criminal Procedure Act. I respectfully submit, my lord, that reliance on section 167 of the Criminal Procedure Act is misplaced. Section 167 is the purview of the presiding officer, not the state, not the defense. The defense and the state can apply for recalling of witnesses that have testified that are present in court, but using a different mechanism, not 167, my lord. And I'm not going to read 167 for the court. All of us who are here are well aware of the provisions of section 167, my lord. At paragraph 2.5, my lord, we submit respectfully that the issues relating to the identification and the description, especially because of what the state says I put to Colonel Gininda regarding what the witnesses said to Warrant Officer Steenkamp, I submit the following, my lord, that these are issues that are matters of credibility that the court is seized with at the end of the case to determine on the credibility as to the description of the witnesses in the house, the description as proffered in their evidence in chief in cross-examination here in court. Re-examining Brigadier Gininda on those issues is not going to change what those witnesses told Warrant Officer Steenkamp. The other issue, my lord, that we address in our heads of argument is the reasons why that evidence was not led in chief. And I submit humbly, my lord, that I've already traversed this, and Advocate Mnisi as well has traversed this. There's case law anecdotal at the end of the state's heads of argument which deal with the interest of justice, and we cannot follow those cases. Multi-choice, all of those cases, my lord, we are well aware of those. But the interests of justice, my lord, are a two-way street. So we implore this court to prioritize fairness, efficiency, and the interest of justice, my lord, in deciding the very fact that we are debating here in court today, my lord. And lastly, my lord, at the end of our heads of argument, we reiterate the same position, that is the right to re-examine by either the state or the defense or by the court, my lord, for that matter. And that are the provisions of section of the CPA, my lord. I'm not going to regurgitate those, my lord. We during our debates previously, my lord, we had traversed those issues. As the court pleases, my lord, that will be my submission, that the court denied the application to recall these witnesses, my lord, and to lead further evidence of Mr. Ndlovu in particular regarding Mr. Ntanzi. As the court pleases, my lord.
Thanks. Yes, Mr.
Thank you, my lord. I will have no submissions.
Nomalo?
I will have no submissions. Thank
Okay,
you.
thanks. Yes, ma'am.
Thank you, my lord. My lord, I have only 2 submissions to make, my lord. On the objections raised by the defense in the inclusion, my lord, of the new evidence. My lord, as my learned friends have submitted the reasons that needs to be considered on this application, and one of the reasons, my lord, is the delay, reason for the delay in leading or in introducing the evidence that a party intends to introduce at this stage. The reason, my lord, which I found on the heads of the argument submitted by the state in respect of accused number 2 is that the state only had an opportunity to go through its own evidence, which is 5,467 photos. And it's only then they realized that the state wanted to introduce this evidence when I read through the heads of the arguments of the state, my lord. My lord, my submission is that so it means the state, at the time when the state was supposed to furnish the defense, in particular accused number 2, with further, full and better particulars in order to enable accused number 2 to prepare his defense, the state did not comply with those provisions, because the state is saying, my lord, on its own heads of arguments, they only had the opportunity to go through the evidence during the adjournment when Advocate Mnisi was preparing for his cross-examination. That on its own, my lord, it shows that the state was reckless in reading and analyzing and preparing the evidence that the state wanted to introduce, that the state wanted to use against accused number 2. It shows that the state from the outset never intended to use the information or the evidence that they now intend to introduce, because it was lying in their hands, but they elected not to introduce such evidence, my lord. And therefore, that on its own has violated the rights of the accused to a fair trial, in that he had not been afforded with an opportunity to prepare his defense case from the outset of the trial. Therefore, the inclusion of this evidence, my lord, will affect the right to a fair trial of accused number 2 on the basis of the reason that has been submitted by the state. Then on the part of accused number 3, my lord, also on the reasons for the delay, the state on its own heads of argument, my lord, indicated that it is the investigating officer who picked and chose the photos that were supposed to be included in Exhibit S, which was presented before this court. Therefore, it means, my lord, at the time when the state was preparing the evidence, the state was in receipt of this evidence, and therefore it was the issue of the investigating officer to pick and choose which evidence to be presented and which evidence not to be presented against accused number 3 in respect of the pictures that the state had at the time when they were preparing Exhibit S, my lord. Also, it means, my lord, the state was negligent on their part. Also, my lord, it goes further to say also the state has failed to give accused number 3 the evidence, or to furnish, not to give, my lord, to furnish accused number 3 with further, full and better particulars in order to enable accused number 3 to prepare his defense case, my lord. Now, the introduction of this new evidence at this stage, my lord, will be prejudicial to both accused because the reason submitted by the state for failure to include such information at the beginning, it shows that they were reckless. The state was reckless, my lord, or did not pay particular attention to the evidence that they intended to use. My lord, I may submit that the inclusion of such evidence will be prejudicial to the accused, my lord. Those are my submissions only, my lord.
Thank you. Any response, sir?
As a court, please, my lord. Well, firstly, as far as the arguments of Advocate Mnisi and Mr. Ramasipele is concerned, there appears to be a serious misconception as to the reason why the state seeks to lead to the evidence. And we are saying this, my lord, with the greatest of respect. If one looks at the argument of Advocate Mnisi, he mentions, for instance, that there's no valid reason as to why the evidence wasn't led through Brigadier Gininda. He also mentioned that there's no explanation as to how we missed the evidence. And if one looks at the argument of Mr. Ramasipele that the photos are not new evidence, that we perhaps are reviewing our strategy, that our strategy was to lead certain evidence, that there's no averment that there was an oversight or omission on the part of the state, that the state wants to have a second bite at the cherry, and that the evidence is repetitive or irrelevant. If one looks at those submissions, my lord, we submit that there's this fundamental misconception of the reason why the state seeks to leave the evidence at this point, my lord. And we've played open cards. We've come before the court and said this evidence, when we let Brigadier Gininda that the photos had not as yet been identified. We mentioned, my lord, in our heads of argument on Friday that it was during the long adjournment, and this we set out in our heads of argument that we presented on Friday, that it was, and this paragraph 2.3, that the reason why the evidence was not presented during evidence in chief is that it was only during the long adjournment that was afforded to Advocate Mnisi to prepare his cross-examination that we were able to trawl through the 5,467 files. And we've come to the court, we've played open cards and said these photos were discovered, and I use discovered in the sense that we were able to identify those photos after the evidence of Brigadier Gininda in chief was led. So in other words, this evidence was not available at the time when, and I'm using the word available in the sense that the photos had not as yet been identified at the time when Brigadier Gininda gave his evidence in chief. Well, Advocate Mshololo then submitted that this is new evidence and mentioned that the state was reckless and that we did not finish the requested further particulars. And as far as accused number 3 is concerned, she submitted that the state failed to give accused 3 or to furnish him with better particulars. The fact of the matter, my lord, is that the photos, as we've indicated, were contained in the disc that was given to all the defense counsel some time ago, and in our submission, my lord, this was sometimes in 2023. We don't want to commit to the year in case we are accused of not putting correct facts before the court. But this is a long while ago, my lord, that the evidence was furnished to the to the defense. I can put it as high as saying that even before the resumption of the trial, that this evidence was furnished to the to the defense. So they can, my lord, we submit with the greatest respect that they it cannot be argued that we failed to furnish further particulars when we furnish this information in a disc before the trial commenced. And my lord, as the trial unfolded, certain propositions were put to the witnesses, and in this regard, we just want to refer to a proposition that was put to Mr. Tumela Madlala. This was on the 8th of August 2023 on page 13, line 14 by Mr. Ramosepeli. He put the following proposition. Now, accused number 2 instructs me that he has never had this beard here. In fact, it does not grow on him, and he has never had an O-shaped beard like you say the second suspect had. And furthermore, that he has always kept the goatee, the one that you see here in court, from as long as he can remember. And my lord, these are some of the aspects that only came during the cross-examination of the witnesses. And my lord, the photos that the state seeks to hand up address these issues that only came to light during the cross-examination of the witnesses. The reason, my lord, why we quoted the passages that appear in our heads was simply to show relevance as to why we want to present the evidence. We therefore submit, my lord, that the state should be given the opportunity to lead this evidence. We have advanced the reasons. We've played open cards with the court, and we are of the view, my lord, that there can be no question of prejudice, my lord, because these are simple photos of the accused. How can a person be prejudiced by the way that he looks? Mr. Ramusepili mentioned the fact that the photos are irrelevant in the sense that there's no date as to when these photos were taken. But one thing is certain, my lord, is that these photos were taken before the arrest of the accused, and therefore, my lord, this will be relevant as far as the period within which the offense was committed is concerned, my lord. We therefore reiterate that the state should be allowed to lead evidence on these photos, my lord. Thank you.
What's the time there?
It's 11:15, my lord.
Okay, can you come take it up first? the most cogent reason is that there are photographs, thousands of photographs. We're not talking about 2 photographs, 6 photographs, thousands of photographs which were downloaded according to the state in this matter. Apparently there are about, it's how much? 7,000.
For number 2, it's
Right,
5,467 files.
And then the others,
For accused number 3, it's over 700.
all right? And then the others.
Those are the only.
So in jointly, it's how many photographs?
It's in excess of 6,000.
Right. As any person with fairness can see, these are thousands and thousands of photographs. And the explanation given by the state is conceivably correct on the basis that it was only during the recess period when the court had recessed because there had to be preparation by accused number 1's counsel to prepare. Then that preparation took about, for a cross-examination, took about 4 months, 3 weeks. And it is during that time of preparation when the state alleges that it was trawling through these thousands of photographs that it came across evidence of the remainder of the photographs, which in perusal thereof, the state thought it advisable to use that evidence. And the gravamen of the matter is that all the accused counsel had this evidence, all of them. They are not taken by surprise. All of them, they had this evidence. This court remembers it had to adjourn for about 2 weeks when all the counsel said they wanted to peruse the photographs. So the state is arguing that this evidence is relevant, and the defense is arguing the contrary, that this evidence is not relevant. It is new evidence. And the premise of the law is as follows. Irrelevant evidence is inadmissible. No evidence as to any fact, matter, or thing shall be admissible which is irrelevant or immaterial and which cannot conduce to prove or disprove any point of fact at issue in criminal proceedings. And I'm reading this from the TOEIC, if you want to read it, page 2422B. The meaning of relevance. The relevance of an item of evidence refers to its logical tendency to show or indicate the material fact for which the evidence is offered. See in this regard the case of R versus Katz, 1946 AD 71 to 77, where Watermeyer, who was then the Chief Justice, approved the following definition by Stephen Digest of the Law of Evidence, 11th edition, 1930, Article 1. I repeat, the word relevant meant that any two facts to which it is applied are so related to each other that according to the common sense of events, either taken by itself or in connection with other facts, proves or renders probable the past, present, or future existence or non-existence of the other. Here we're talking about photographs. So we're not talking about hypothetical evidence. We're talking about material photographs. And as I listen to the argument of the defense of the accused is not affected in essence. In other words, the defense of the accused remains the same. They know nothing about the so-called alleged murder of the deceased. They were not there at any time. They know nothing about that. So the defense remains constant and consistent. So the prejudice, if any, is it has been tendered at a later stage, but the state has proffered compelling and compellable evidence that this evidence, although it can be categorized as new, it has relevance to this case, and it is related to all the evidence that has been led in this case, that of photographs. And we talked about the photographs being about 5,000 or 7,000.
Thank you, guys.
Thank you, guys.
Bye.
Bye-bye. Finally, it's over.
This is just the beginning.
Because according to Mr. Baloyi, on behalf of the state, 3 weeks or so, the same photographs which were discovered by Mr. Malone was tendered to all the defense counsels, and they were advised that the state intends leading that evidence. So let's see if this evidence is now taken out of a hat like a rabbit of a magician. According to Baloyi, it was tendered, there were discussions, there were postponement of the discussions, and when I listened to the two parties, they met, but somebody was saying, no, you're lying, the other one saying, no, it's not true, etc., etc. But the fact of the matter is, no person was ambushed. Okay. In the case of R versus Mpanza, 1915 AD, 343 to 352 to 3, and R versus Torpedo, 1920 AD, 56 to 62. The learned judge just said, I paraphrase, clearly then, questions relating to relevance may not be resolved by resorting to juridical formulae, but rather to reason, common sense, and for Schreiner, the former judge of appeal, who was supposed to have been our Chief Justice, but because of politics, he was never appointed, like a friend of mine, whose name I shall not mention. Clearly, the question relating to relevance may not be resolved by resorting to juridical formulae, but rather to reason and common sense, and as observed by Schreiner. It is based upon a blend of logic, experience, lying outside the law. Okay, now the prosecutor has a duty to bring all the evidence which they believe affects the adjudication of the case. Some 2, 3, 5 months back, I had reason in this court to tell you about a case. I just forget the citation, but I'll give you the facts. Where the SCA, 5 judges of the SCA were adjudicating a matter on argument at the SCA, and at the last minute, the state applied for a postponement in order to apply to reopen the state case because they had found certain relevant evidence. Even at that late stage, the SCA, 5 judges, said, we will grant the postponement, we will grant the reopening of the state case. The only question was whether, should we do it, because that case was in the regional court, should we do it in the regional court or should we do it in a high court? but the principle has been established in our law that if the state has cogent, reasonable, admissible evidence, and it has occasion to require it in the proving of a case, it is entitled, in terms of the law, not rata, in terms of the law, to do so. And I take comfort in the duties which the state the prosecution rather, this national legislation in the National Prosecuting Authority. 2 sections of that act are relevant for the present purposes, namely Section 32 and Section 26(6). 1A, a member of the prosecuting authority shall serve impartially and exercise, carry out, or perform his or her powers, duties, and functions in good faith and without fear, favor, or prejudice, and subject only to the Constitution and the law. And there is further the authority of the Code of Conduct for members of the National Prosecuting Authority in terms of the Government Notice R 1257, in Government Notice 33907 of 29 December 2010, where the following is said: independence, the prosecutorial discretion to institute and to stop criminal proceedings should be exercised independently in accordance with the prosecution policy and the policy directives, and be free from political, public, and judicial interference. Prosecutors should perform their duties without fear, favor, or prejudice, and in particular, they should carry out their functions impartially and not become personally as opposed to professionally involved in any matter. And 2B, they must avoid taking decisions or involving themselves in matters where a conflict of interest exists or might possibly exist. And they also must take into consideration the public interest as distinct from the media or partisan interest and concerns, however vociferous this may be presented. And further, prosecutors, in terms of the International Association of Prosecutorial Standards, which contain the following relevant provisions: impartiality, prosecutors shall perform their duties without fear, favor, or prejudice. In particular, they shall carry out their functions impartially, remain unaffected by individual or sectional interest in public and media pressures, and shall have regard only to the public interest and act with objectivity. And the role of prosecutors in criminal proceedings: they shall perform, I repeat, their duties fairly, consistently, and expeditiously. And in the institution of criminal proceedings, they will proceed only when a case is well-founded upon evidence reasonably believed to be reliable and admissible, and will not continue with prosecution in the absence of such evidence. Throughout the course of the proceedings, the case will be firmly but fairly prosecuted and not beyond what is indicated by the evidence. We further refer to the judgment in the Supreme Court of Canada by Boucher in the case of the Queen versus Boucher versus the Queen, 1955, SCR 16. It's a constitutional court case in Canada, The learned judge has this to say, Judge Rand. It cannot be overemphasized that the purpose of a criminal prosecution is not to obtain a conviction. It is to lay before a jury what the Crown considers to be credible evidence relevant for what is alleged to be a crime. Counsel have a duty to see that all available legal proof of the facts is presented. That's a duty on the state. It should be done firmly, fairly, and to its legitimate strength, but it must also be done fairly, and the role of the prosecutor excludes any notion of winning or losing. His function is a matter of public duty with which in civil life or this can be done and none can be charged with greater personal responsibility. It is to be efficiently performed with an ingrained sense and dignity, the seriousness and the justness of the judicial prosecution. Now, this court is persuaded because the state is saying this evidence is relevant and it is connected to the case and it doesn't materially change according to the defense proffered by the accused. They pleaded not guilty and they proffered during the cross-examination of some of the witnesses, they proffered defenses which range from, we were not there, we know nothing about that, the state's evidence is not correct, etc., etc. Consequently, in the interest of justice, the court admits that the state is entitled to lead those two witnesses if it so desires, and the application is acceded to. Yeah.
abameli ade bephendula kusona isicelo siqhamukile ke siqhamukiswa ithimba noma yebo ithimba labashushisi ke lapho ke banodaba lokuthi babuzeke imibuzo noma balethe ufakazi obusha ke maphicelezi nezithombe lezi ke kade bekhulumile ngazo ithombe zomsolo oqaza osibili futhi nesithathu ke lapho ke kade babala khona ukuthi ithombe eziyishumi nesithupha futhi ezinike uma ngabe ziphelele ke futhi ke kade kwithombe eziyi19 ke kepha kummelweni ke namuhla Adv Mnisi ke akanqaba bathizeni ke lapho ke ithimba labashushisi likhulumeke ngodaba lokho lezithombe ngoba ke basho khona ukuthi bona ke ubrigadier Kinda kumele akumele ukuthi ube ufakazi ke lo yena ke olethe ufakazi lobomphecelezi malana nodaba lezithombe ke lezo ke la kade bekhuluma khona kepha bathi ke kumele ukuthi kube abantu ke laba kade bekhona ke ngaphakathi kwekole lakhaya noma ngaphakathi komuzi ke bekhona ngelanga leli sigameko kumele kube yibona ke abatshela imali nendlela noma manje nesikhangiso ke salomuntu othizeni noma ke abantu kade bangena ke kulela khaya ke leliyana ke futhi ke basho khona ukuthi kade khona ke uchwepheshe lapho kade asebenza malana nodaba lezithombe phecelezi kade khona ngaphambi kungesankantolo ufakazi bakhe ke lapho ke futhi umuntu othuleke ithombe lezo basho njalo ukuthi ade ku warrant officer endlovu ke lapho ke futhi ade asebenza phecelezi no sergeant Mabasa ke lapho ke futhi ade kuyibo abantu kade bethula ufakazi bethombe lezi ke lapho ke futhi nomeli wesibili ke wanqaba ekuthizeni ke malana nodaba lezithombe lezi ekuthizeni bazijobelele ukuthi kungani bengalethile ufakazi malana nezithombe lezi ke ngesikhathi lesi kade ihlaka ithimba noma ihlangothi labashushisi ke lapho ke kade lehola ke imibuzo makade behamba phambili bebuza ke imibuzo yokufakazi ukuthi kungani kumele ukuthi bamele isikhathi lesi ke lapho ke so ukuthi babuze manje malana nodaba lezithombe ke lapho ke babuya futhi basho khona bathi abazi ukuthi ithombe liqhamuka kuphi ucingo lwakabani noma futhi ilanga lakhona bazitholakala kuphi futhi bathi asiyazi indlela kade nitshangala ngayo ke ngomnyaka 2014 futhi ngelanga lesigameko ke futhi kungani ngaphakathi kwezithombe zonkana lezi kade zikhona ke ngaphansi kumibukiso ka sekukuthi lezithombe lezi kade bengakhulumile ngazo ke lapho ke kepha kungani kade bebeke eceleni bengakhulumile ngazo ngesikhathi lesi kade behola ufakazi babo noma kade behola ithimba lofakazi babo ke lapho ke babuya futhi bakhuluma malamba phecelezi nodaba lokuthi kade khona umuntu othizini lapho ke sithi uchwepheshe osebenza ngokwenza uqhathanisa phakathi kwendlela umuntu abukeka ngayo ke lapho ke futhi akhuluma nokuthi ithombe lezi ke bathi ithombe eqhamuka ngaphakathi kuma cellphones wenu noma kumakhala kukhuni benu ke lapho ke futhi babuya futhi basho ukuthi basho khona zonke ezinye ithombe zakhona ke ziqhamuka ngaphakathi kwama SD card ke lapho ke bathi futhi bade benqaba ke ithimba leni labashushi ithimba labameli ke lapho ke ukuthi izini bakhulume phecelezi noma kulethe ufakazi ke obusha ke phecelezi nodaba lolu kwele ithombe ke lapho ke manje isiqinqo senkosi enkantolo ke naso siyasho siyahambisa sithi sona ke siyahambisana ke nethimba labashushisi ekuthizeni ke udaba lolu ke lokuthi baphinde bavusele icala futhi ngokuthi babuza ke imibuzo ke noma bahole lobufakazi obusha ke ukuthi ithi inkosi enkantolo kwamele ukuthi lokhu kwenzeke ke ngoba babona ukuthi lapho ke ubulungiswa futhi bungaphansi bobulungiswa bezomthetho ke ekuthizeni ngabe ithimba labashushisi lifisa ukuthi ujobelele ke udaba lwalo ke lapho ke nokufamelana nofakazi obusha ke kwamele lokho kwenziwe ke futhi ngoba kungaphansi kwezomthetho futhi wakhuluma khona njalo lapha kade enza ke sibonelo khona ke mala nethimba lenkosi zenkantolo ade sihlezi kwicala ke lapho ke lathi khona kade khona ke inkulumo efana ngamashina lena esithola ke njengamanje ekuthizeni lapho kade ihlangwe ithimba noma ihlangothi ke labashushisi kade lifisa ukuthi ke lapho liphinde libuyisele icala lalo ke futhi mala nofakazi ade bukhethekile ke lapho ke futhi yasho ukuthi nakule icala iyahambisana nenkulumo elethiwe lapho ke ithimba labashushisi ukuthi balethe ufakazi obusha ke phecelezi mala nodaba lwezithombe.
Yes.
As a court, please, my lord, the state will be calling Warrant Officer LT Ndlovu. He was delayed this morning, my lord. He's traveling from Middleburg and he's just returned from leave. He's just relayed the message that he's about 30 minutes away. If we cannot take the long adjournment at this point and resume it at 2.
At 2. Okay, fine.